9. Pursuant to the natural right and duty of parents over the person and property of their unemancipated children, parental authority and responsibility shall include the caring for and rearing them for civic consciousness and efficiency and the development of their moral, mental and physical character and well-being. N. Article 210. Parental authority and responsibility may not be renounced or transferred except in the cases authorized by law. 313a. Article 211. The father and the mother shall jointly exercise parental authority over the persons of their common children. In case of disagreement, the father's decision shall prevail, unless there is a judicial order to the contrary. Children shall always observe respect and reverence towards their parents and are obliged to obey them as long as the children are under parental authority. 311a. Article 212. In case of absence or death of either parent, the parent present shall continue exercising parental authority. The remarriage of the surviving parent shall not affect the parental authority over the children, unless the court appoints another person to be the guardian of the person or property of the children. N. Article 213. In case of separation of the parents, parental authority shall be exercised by the parent designated by the court. The court shall take into account all relevant considerations, especially the choice of the child over 7 years of age, unless the parent chosen is unfit. N. Article 214. In case of death, absence, or unsuitability of the parents, substitute parental authority shall be exercised by the surviving grandparent. In case several survive, the one designated by the court, taking into account the same consideration mentioned in the preceding article, shall exercise the authority. 355a. Article 215. No descendant shall be compelled, in a criminal case, to testify against his parents and grandparents, except when such testimony is indispensable in a crime against the descendant or by one parent against the other. 315a. Chapter 2. Substitute and special parental authority. Article 216. In default of parents or a judicially appointed guardian, the following person shall exercise substitute parental authority over the child in the order indicated. The surviving grandparent, as provided in Art. 214. The oldest brother or sister, over 21 years of age, unless unfit or disqualified, and the child's actual custodian, over 21 years of age, unless unfit or disqualified. Whenever the appointment or a judicial guardian over the property of the child becomes necessary, the same order of preference shall be observed. 349a, 351a, 354a. Article 217. In case of foundlings, abandoned, neglected or abused children and other children similarly situated, parental authority shall be entrusted in summary judicial proceedings to heads of children's homes, orphanages, and similar institutions duly accredited by the proper government agency. 314a. Article 218. The school, its administrators and teachers, or the individual, entity or institution engaged in child or shall have special parental authority and responsibility over the minor child while under their supervision, instruction, or custody. Authority and responsibility shall apply to all authorized activities whether inside or outside the premises of the school, entity, or institution. 349a. Article 219. Those given the authority and responsibility under the preceding article shall be principally and solidarily liable for damages caused by the acts or omissions of the unemancipated minor. The parents, judicial guardians, or the persons exercising substitute parental authority over said minor shall be subsidiarily liable. The respective liabilities of those referred to in the preceding paragraph shall not apply if it is proved that they exercised the proper diligence required under the particular circumstances. All other cases not covered by this and the preceding articles shall be governed by the provisions of the Civil Code on quasi delicts. N. Article 220. The parents and those exercising parental authority shall have with the respect to their unemancipated children on wards the following rights and duties. To keep them in their company, to support, educate and instruct them by right precept and good example, and to provide for their upbringing in keeping with their means. To give them love and affection, advice and counsel, companionship and understanding. To provide them with moral and spiritual guidance, inculcate in them honesty, integrity, self-discipline, self-reliance, industry and thrift, stimulate their interest in civic affairs, and inspire in them compliance with the duties of citizenship. To furnish them with good and wholesome educational materials, supervise their activities, recreation and association with others, protect them from bad company, and prevent them from acquiring habits detrimental to their health, studies, and morals. To represent them in all matters affecting their interests. To demand from them respect and obedience. To impose discipline on them as may be required under the circumstances, and to perform such other duties as are imposed by law upon parents and guardians. 316a. Article 221. Parents and other persons exercising parental authority shall be civilly liable for the injuries and damages caused by the acts or omissions of their unemancipated children living in their company and under their parental authority, subject to the appropriate defenses provided by law. 2180, 2a and 4a. Article 222. The courts may appoint a guardian of the child's property or a guardian ad litem when the best interests of the child so requires. 317. Article 223. The parents or, in their absence or incapacity, the individual, entity or institution exercising parental authority, may petition the proper court of the place where the child resides, for an order providing for disciplinary measures over the child. The child shall be entitled to the assistance of counsel, either of his choice or appointed by the court, and a summary hearing shall be conducted wherein the petitioner and the child shall be heard. However, if in the same proceeding the court finds the petitioner at fault, irrespective of the merits of the petition, or when the circumstances so warrant, the court may also order the deprivation or suspension of parental authority or adopt such other measures as it may deem just and proper. 318a. Article 224. The measures referred to in the preceding article may include the commitment of the child for not more than 30 days in entities or institutions engaged in child care or in children's homes duly accredited by the proper government agency. The parent exercising parental authority shall not interfere with the care of the child whenever committed, but shall provide for his support. Upon proper petition or at its own instance, the court may terminate the commitment of the child whenever just and proper. 391a. Article 225. The father and the mother shall jointly exercise legal guardianship over the property of the unemancipated common child without the necessity of a court appointment. In case of disagreement, the father's decision shall prevail, unless there is a judicial order to the contrary. Where the market value of the property or the annual income of the child exceeds P50,000, the parent concerned shall be required to furnish a bond in such amount as the court may determine, but not less than 10% of the value of the property or annual income, to guarantee the performance of the obligations prescribed for general guardians. A verified petition for approval of the bond shall be filed in the proper court of the place where the child resides, or, if the child resides in a foreign country, in the proper court of the place where the property or any part thereof is situated. The petition shall be docketed as a summary special proceeding in which all incidents and issues regarding the performance of the obligations referred to in the second paragraph of this article shall be heard and resolved. The ordinary rules on guardianship shall be merely suppletory except when the child is under substitute parental authority, or the guardian is a stranger, or a parent has remarried, in which case the ordinary rules on guardianship shall apply. 320a. Article 226. The property of the unemancipated child earned or acquired with his work or industry or by onerous or gratuitous title shall belong to the child in ownership and shall be devoted exclusively to the latter's support and education, unless the title or transfer provides otherwise. The right of the parents over the fruits and income of the child's property shall be limited primarily to the child's support and secondarily to the collective daily needs of the family. 321a, 323a. Article 227. If the parents entrust the management or administration of any of their properties to an unemancipated child, the net proceeds of such property shall belong to the owner. The child shall be given a reasonable monthly allowance in an amount not less than that which the owner would have paid if the administrator were a stranger, unless the owner grants the entire proceeds to the child. In any case, the proceeds thus give in whole or in part shall not be charged to the child's legitime. 322a. Chapter 5. Suspension or termination of parental authority. Article 228. Parental authority terminates permanently upon the death of the parents, upon the death of the child, or upon emancipation of the child. 327a. Article 229. Unless subsequently revived by a final judgment, parental authority also terminates upon adoption of the child, upon appointment of a general guardian, upon judicial declaration of abandonment of the child in a case filed for the purpose, upon final judgment of a competent court divesting the party concerned of parental authority, or upon judicial declaration of absence or incapacity of the person exercising parental authority. 327a. Title X. Emancipation and age of majority. Article 234. Emancipation takes place by the attainment of majority. Unless otherwise provided, majority commences at the age of 21 years. Emancipation also takes place by the marriage of the minor, or by the recording in the civil register of an agreement in a public instrument executed by the parent exercising parental authority and the minor at least 18 years of age. Such emancipation shall be irrevocable. 397a, 398a, 400a, 401a. Article 235. The provisions governing emancipation by recorded agreement shall also apply to an orphan minor and the person exercising parental authority, but the agreement must be approved by the court before it is recorded. N. Article 236. Emancipation for any cause shall terminate parental authority over the person and property of the child, who shall then be qualified and responsible for all acts of civil life. 412a. Article 237. The annulment or declaration of nullity of the marriage of a minor or of the recorded agreement mentioned in the foregoing Articles 234 and 235 shall revive the parental authority over the minor, but shall not affect acts and transactions that took place prior to the recording of the final judgment in the civil register. N. Title 11. Summary Judicial Proceedings in the Family Law. Chapter 1. Prefatory Provisions. Article 238. Until modified by the Supreme Court, the procedural rules provided for in this title shall apply as regards separation in fact between husband and wife, abandonment by one of the other, and incidents involving parental authority. N. Chapter 2. Separation in fact. Article 239. When a husband and wife are separated in fact, or one has abandoned the other and one of them seeks judicial authorization for a transaction where the consent of the other spouse is required by law but such consent is withheld or cannot be obtained, a verified petition may be filed in court alleging the foregoing facts. The petition shall attach the proposed deed, if any, embodying the transaction, and, if none, shall describe in detail the said transaction and state the reason why the required consent thereto cannot be secured. In any case, the final deed duly executed by the parties shall be submitted to and approved by the court. N. Article 240. Claims for damages by either spouse, except costs of the proceedings, may be litigated only in a separate action. N. Article 241. Jurisdiction over the petition shall, upon proof of notice to the other spouse, be exercised by the proper court authorized to hear family cases, if one exists, or in the regional trial court or its equivalent sitting in the place where either of the spouses resides. N.